morning, everyone, and welcome to session 3 of Bracewell's Environmental Law Seminar Fall 2020. Hopefully, I will get to see all of you in person in the spring. So our third session is entitled The Clean Water Act, the Good, the Bad, and the Muddy. And there's certainly a lot to talk about when it comes to the Clean Water Act. So today we're going to cover a cornucopia of Clean Water Act topics, which is certainly a bountiful feast under the Clean Water Act. First, we're going to talk a little bit about the geographic jurisdiction of the Clean Water Act, and Daniel Pope will cover that topic. Then we'll move in order to Section 401 of the Clean Water Act with Kevin Voelkel, then to Section 402 with Sara Burgin, and I'll wrap up with some issues under Section 404 of the Clean Water Act. So handing it off to Daniel.
Thanks, Anne, and thank you all for being with us this morning. Anne outlined the various regulatory programs we'll be discussing today, but one thing that all those programs have in common is that jurisdiction and obligations under those programs depend on the existence of federal Clean Water Act jurisdiction. The Act applies to navigable waters, which are in turn defined by the Act as, quote, the waters of the United States. One of the key issues for the outgoing administration's agenda has been to revise the regulatory definition of the waters of the United States, or WOTUS as it's commonly called, and the administration finalized its new WOTUS rule earlier this year. Now, some of you have seen our presentations in the spring seminar and in our webinars about the WOTUS rulemaking process. And so I'm not going to be going into too much detail on the rule itself. Although if you're new to our seminar or would otherwise like those presentations, I'd love to get them to you. My email is going to be on the final slide of this presentation, so please reach out. But I do want to set the table here before we jump into the current state of play on the 2020 rule. In 2015, as some of you will remember, the Obama administration promulgated a WOTUS rule that sought to achieve the goals of the Clean Water Act by protecting upstream features and wetlands that were hydrologically connected to tributaries, traditionally navigable waterways, and the stuff you kind of think about when you think about a navigable waterway or a WOTUS. My shorthand for thinking about that 2015 rule is that it basically outsourced a legal question, whether the Clean Water Act applies, to scientists and consultants who would go out into the field or observe a wetland or a waterway and make scientific judgments about the type of connection that water body had to a downstream feature. And what that also meant for regulated entities was that before you could get on with your project, you need to expend some significant resources to figure out whether a possible site was regulated under the Act. That 2015 rule was quite controversial and ended up being successfully challenged by states and businesses alike, and it ended up applying in less than half the country. So in addition to disagreeing with the rule on purely legal grounds, the Trump administration also needed to make sure that there was some uniformity across the country for this definition. In 2019, it repealed that 2015 rule, or what remained of it. And so we had a brief return to 1986 regulations. That was the last time that rules had been promulgated defining what the phrase waters of the United States meant. And then earlier this year, the Trump administration finalized the Navigable Waters Protection Rule. That's the current rule that we have for waters of the United States. And we've talked a few times in our seminars and presentations about this administration's goals. One way I think about it, if the 2015 rule outsourced legal questions to science, this administration put law back over science. The statutory text of the Clean Water Act and case law, specifically a number of Supreme Court cases, were more important for this administration than scientific conclusions about the connections between different kinds of water bodies. The administration also wanted to have predictability and reliability so that the rule could be relatively easily understood, that it could be applied consistently, and that you wouldn't have something we had for the past several years, where companies with operations in multiple states might be scratching their heads about which version of WOTUS applied. And so the 2020 rule ended up being a major achievement for the administration's regulatory reform agenda, and was one of the things that was covered a lot in the trade press. Now, of course, the 2020 rule was challenged very quickly. The first set of challenges sought to preliminarily enjoin the rule from going into effect, and that set of challenges mostly failed everywhere except for Colorado. The 2020 rule is currently in effect everywhere but for that state. A number of challenges really focus on saying that the rule has done too little to protect clean water, and I'm going to discuss some of those briefly. But there are other challenges from conservative and libertarian groups, like the Pacific Legal Foundation, saying that this 2020 rule still goes too far. Those lawsuits, have really stalled out at this stage. I'm still following them, but it seems like the real challenges are from states and NGOs. Some of the cases that are currently underway have reached the summary judgment stage. For example, the South Carolina Coastal Conservation League straight up skipped the preliminary injunction fight and went straight for summary judgment. There's actually going to be a hearing on summary judgment tomorrow in that case. We also have the Conservation Law Foundation versus EPA. Their briefing will be complete in February of next year. So we're actually getting to the point where over the first half of next year, we're going to be seeing some determinations about whether this rule is valid under the Clean Water Act and under Supreme Court precedent. The Colorado versus EPA decision, where the District Court of Colorado enjoined the application of the 2020 rule in Colorado, that's actually going to be argued on appeal. This has actually already been argued on appeal, so I'm going to be looking forward to a decision on that. And just so you know, there are really only a handful of arguments that are being advanced against the new rule. Some NGOs are arguing that the latest Supreme Court decision addressing the WOTUS issue, a case called Rapanos versus United States from 2006, conclusively rejected the idea that there's got to be a continuous surface connection. Now, that's the plurality opinion in that case, written by the late Justice Scalia. He wrote that there has to be a continuous surface connection between a traditionally navigable waterway or a tributary and some upstream feature that would support the application of the Clean Water Act to that upstream feature. These NGOs are arguing that, well, that Scalia's opinion only got 4 votes, and there are 5 votes that disagree with the continuous surface connection test. And so there really is kind of a secret majority holding in Rapanos. And the courts really haven't been too kind to that argument so far under existing precedent about how you interpret really fractured opinions like Rapanos. NGOs are also arguing that the Navigable Waters Protection Rule ignores scientific evidence about the connections between upstream features and downstream waters in favor of a more legal categorical approach that doesn't account for those kinds of hydrological connections. These NGOs argue that basically the Trump administration's ignored EPA's previous findings of fact about those connections between water bodies. But if you'll recall from some of our earlier presentations, the Trump administration has really been trying to go upstream, if you'll allow me to make that analogy, upstream of those kinds of fact issues to say that the Clean Water Act really is a legal question first before we worry about what the facts on the ground are. We need to have a solid understanding of the statute. So they're really making a more legal argument there anyways. Other NGOs will argue that somehow this 2020 rule has misread the Clean Water Act, either in not putting enough of an emphasis on the stated purpose of the statute, which is to restore and maintain the chemical, physical, and biological integrity of the nation's waters, or that it reserves too much of a place for the states to make their own choices about water policy, especially groundwater resources. Colorado made kind of an interesting version of this argument. when it was describing the irreparable harm that the state of Colorado would experience from this rule going into effect, it said, well, Colorado has not actually promulgated very many rules to protect its own water quality. It has been relying on the federal government to promulgate such rules and to enforce those rules in the state. So despite the fact that, this has been on the Trump administration's agenda for quite some time, Colorado said it would be harmed by having to adopt new enforcement procedures. And DOJ has made a very, very big argument about that concept of harm. But anyways, South Carolina Coastal Conservation League is going to be one of the first across the summary judgment finish line. And of course, we're going to be following that for you. I want to talk a little bit about what the incoming administration might do with respect to the WOTUS rule. Now, as you know, especially if you've attended our first two presentations in this seminar, that climate change is going to be a major focus for the Biden administration. And many of the progressives who supported Joe Biden's candidacy, when they may not have supported him during the primary, have articulated that Joe Biden has a climate mandate, that he's basically obliged to take aggressive action on climate change. And so that's been a major focus of a lot of the coverage of the transition so far, particularly as it relates to environmental and energy matters. But the TrumpWOTUS rule was still really controversial among NGOs. And so we're going to be following that. And we all expect that there will be some kind of action with respect to the TrumpWOTUS rule. President-elect Biden is making a number of announcements about his cabinet picks and has articulated that we're going to be seeing some more economic focused picks this week. We'll, of course, be following who might be appointed to EPA and other key positions that might affect the TrumpWOTUS rule. One thing I thought was interesting, though, that you might like to know is that President-elect Biden's transition team includes a longtime member of Capitol Hill, Ken Kaposis. He's served on a number of House and Senate committees, and most recently, he was the head of the Office of Water during the Obama administration. He left that position in 2015 after he shepherded the 2015 WOTUS rule across the finish line. Ken Kaposis and a few others are advising the president-elect on a number of issues at EPA, and will be involved with setting the agenda for President-elect Biden's EPA picks and working with them to identify key areas where the president-elect needs to address what was done over the past 4 years. So there are a few options for the Biden administration. Defend the rule tooth and nail? Maybe not. I don't think that the Biden administration is going to be pushing really hard to defend the rule. And so we may see settlements. We may see DOJ asking for a stay. We may see the administration request a voluntary remand of the rule. Like I mentioned a few moments ago, I do think we are going to see some decisions on the merits before we actually see a number of settlements or stays or remands of the rule. And so we are going to have some legal determinations. How extensive those are, of course, remains to be seen and will depend in large part on the timeline that the Biden administration has for this activity. Are we going to see a subsequent rulemaking activity? Would we see a comprehensive rulemaking, sort of like another version of the 2015 rule to supplant the Navigable Waters Protection Rule? Anne's told me that she'll cut off my mic if I call a Joe Biden WOTUS rule JOTUS. So I'm just going to save that for future presentations. But I think that's a real question. And of course, we might see the same kind of two-step repeal and replace process we saw with the 2015 WOTUS rule. So we'll be paying attention to that. Another thing that I could envision happening with subsequent rulemaking activity is that there could be additional rulemakings to add new categories of jurisdiction. The 2020 WOTUS rule was took a categorical approach to jurisdiction. Basically, if you were in one of these four categories, then the water body was governed by the Clean Water Act. And it also promulgated a number of exceptions. Well, could there be a fifth category or a sixth category of jurisdiction added? That might be a more piecemeal approach, and it might be less controversial than the wholesale rewrite of the waters of the United States, which, if it happens in a few years, we will have gone through three major regimes of WOTUS definitions in less than a decade. Whatever steps the Biden administration takes, the lawsuits are going to flow. One thing that's interesting, I looked at some statistics recently. There are about 870 Article 3 judges and justices. 227 of those, or about a quarter, are Trump appointees. And of course, we've talked at length about the judicial philosophies behind some of those picks. One of the central questions, though, that I think is going to really shape the 2020 rule and any subsequent rulemaking activity is whether or not a case gets to the Supreme Court again. One of the main issues that has been difficult for both the Obama administration and the Trump administration, and if there's no change will be a difficulty for the Biden administration, is the Rapanos versus United States decision from 2006. There's a Scalia plurality opinion. I talked about that a little bit earlier. That uses a continuous surface connection test to establish the jurisdiction of the Clean Water Act. And that plurality opinion was joined by three members of the court, Chief Justice Roberts and Justices Thomas and Alito. Justice Kennedy's concurrence in Rapanos articulated the significant nexus test, and that was really the focus of the 2015 rule. Navigating both of those opinions, though, has been very difficult. But we have a new SCOTUS. We have a new Supreme Court with three new Trump appointees: Justice Gorsuch, who was a Kennedy clerk, Justice Barrett, who was a Scalia clerk, and Justice Kavanaugh. And they'll likely, during their tenure on the Supreme Court, have an opportunity to speak to the WOTUS issue. I'm curious if there will be any pressure on Justice Breyer, who dissented from the Rapanos decision. I wonder if there will be any pressure on him to retire during this administration. A legislative solution to revise the definition and amend the Clean Water Act does seem unlikely, even if the Democrats win in the Georgia runoffs. And Ken Kaposis, who I mentioned earlier, doesn't think so. In a 2017 interview he gave, he was skeptical about the possibilities of major legislative action to upgrade the Clean Water Act. And so until we have a new Supreme Court decision or less likely legislative solutions, we're probably going to be stuck in the same executive action and litigation mode that we've been in. And so because we're going to be in this process of seeing new rules challenged and seeing potentially subsequent rulemakings, we're going to be paying attention to whatever's going on with WOTUS so that you can stay updated on the current state of play. Now, my colleague in DC, Kevin Voelkel, is going to discuss the implementation of the 401 Water Quality Certification Rule. Kevin?
Thanks, Daniel. As Daniel mentioned, I'm going to provide an overview and update of the Clean Water Act Section 401 reforms. And really, at a high level, Section 401 prohibits federal agencies from issuing final permits until after affected states have had a reasonable time, which cannot exceed 1 year, to say whether the project being considered will comply with applicable water quality standards. It's one of the many environmental statutes that are built on the principle of cooperative federalism and provides a role for the states in a federal framework. But what we've seen is in the last few years in particular, certain major projects have been delayed or even outright prevented by states delaying or denying their Section 401 review in ways that stretch or depart from the statute. And so the Trump administration, through EPA, has implemented several reforms, most notably a July 2020 final rule that seeks to prevent some of the tactics that have been used to delay these projects. And so to set the stage, the language on this slide provides an overview of the 401 framework, and certain key terms are emphasized. But in looking how the framework operates, Section 401 prohibits federal agencies from issuing permits or licenses for activities that may result in a discharge into waters of the United States, as Daniel was just discussing. And so it prohibits the agencies from issuing these permits or licenses unless the affected state issues a certification that the discharge will comply with applicable provisions of the Clean Water Act or other appropriate requirements of state law. And just to clarify terminology here, I'm going to be referring solely to the states during this presentation, but it can also be what's called any certifying authority. And so that includes certain tribes or EPA itself in certain circumstances can serve as the certifying authority. And so the options for action by the state, it can either grant a 401 certification, in which case the federal agency may issue the permanent compliance with the section. A state can conditionally grant a 401 certification, in which case the federal agencies must include the conditions identified by the state in the federal permits themselves. The state can deny a certification, in which case the federal agency is prohibited from issuing the federal permit. And the state can affirmatively waive its certification. And so this is not very common, but from the federal agency's perspective, this would be similar to the state granting the certification, because the result is that the federal agency may issue the permit without any additional conditions in compliance with the statute. And so the statute requires the state to act on a 401 certification request within a reasonable period of time. And the statute specifies that a reasonable period of time cannot exceed 1 year. If the state fails to act within this time, then the state waives its certification. So we're going to take a look at the Trump administration's reform actions, but before we do, I want to note a few of the emphasized terms in this slide because they underline the ambiguity that have been used to frustrate projects. So first, the water quality certification itself. A key source of the disagreement here has been that the scope of the water quality certification. So what grounds can the state deny a request for certification under the umbrella of 401? So on the one end of the spectrum, you have sort of very non-controversial denial of 401 certificates based on a direct impact to water quality. But on the other end of the spectrum, you have more controversial bases. So you have denials, for example, for the inadequate analysis of greenhouse gas emissions. And then you also have conditions on approvals. So one of the things that gained some attention was there was a practice of requiring like the construction of biking or hiking trails. And so these are really bases and the scope of 401 being asserted that many felt were sort of beginning to stretch the statutory framework. Another source of ambiguity involves the certification request made by the project proponent. And so the statute clearly requires action on a certification request within the reasonable period of time, again, not to exceed 1 year. But some states were asserting a position that an application by a project proponent only constituted a request if it was complete, and that determining whether it was complete, the states, not surprisingly, many asserted was their determination to make. So if a request was received by the state on January 1st, if the state deemed the request complete only on, say, June, then some states were treating June as the start of the statutory clock, even though the initial request had been made much earlier. So forms of this approach have been rejected by the Second Circuit in a 2018 case, but until the July 2020 rule that we're going to talk about, EPA regulations had not yet been revised consistent with the court's holding there, and nor had the holding been uniformly adopted across circuits. And then the final term I'd like to highlight is also closely tied to the timing of the certification request. And it involves the practice of project proponents withdrawing and resubmitting 401 applications. And this was done particularly as the one-year deadline was approaching, and it was done in order to restart a new one-year time period. And so this resulted in a process by which a single application could be reviewed by a state over years and years, even if it remained essentially the same application. So this practice also was found to violate Section 401 when the DC Circuit rejected it in the important Hoopa Valley case in January 2019. But like the timing issue, the court's holding there had not been reflected in EPA's regulations. So now I just wanted to take a look at the Trump administration's reform actions. And so what we see is that the administration followed a familiar and traditional sequence of events in pursuing regulatory reform, and that culminated in the July 2020 final rule by EPA. So first, in April 2019, Executive Order 13868 was issued, and it directed EPA to update its guidance and regulations and convene a working group to update the guidance and regulations of other agencies on the 401 issue. So it specifically directed EPA to focus on the issues of the scope of water quality certifications we just talked about, and also the timing considerations. And so this was sort of the first kind of substantive look at what the administration was prioritizing, and we see that scope and timing considerations were front and center. Then in June 2019, EPA issued guidance on the Section 401 issue, and the guidance withdrew prior interim guidance and replaced it with a guidance that again addressed the statutory and regulatory timelines for review and the appropriate scope of the certification review and conditions. So in August 2019, EPA issued a proposed rule that eventually resulted in the July 2020 final rule. And the final rule, not surprisingly, built off of the areas identified in the April executive order and the June 2019 guidance document to address a number of issues, including these sources of tensions that we've discussed concerning the timing and scope of certification. And so first, it clarified that the scope of a state's review to ensure that the state's review is limited to the enumerated provisions of the Clean Water Act, meaning those specifically identified in Section 401 as state requirements from point source discharges into waters of the United States. And so this is done to prevent states from looking at upland impacts and other non-point source impacts. It also defines the process and the time period for requesting action on a 401 certification. So it clarifies that the state's review starts upon the receipt by the state, and it defines a criteria for a certification request for the first time. And so, again, these are measures designed to provide a clear point of when the one-year clock starts. It doesn't prevent the state from requesting additional information, but receipt of the additional information no longer can be used to trigger a new one-year period. And then one other area that I wanted to note, the rule provides clarity on the roles of state and federal government. And again, because this Section 401 does involve sort of the principle of cooperative federalism, what we see is a lot of the tension was arising between what's within the authority of the state and what's within the authority of the federal agencies, who are really the ones who are being prevented from issuing the federal permit. So it's the federal permit that's kind of driving that's driving the action here. And so what the rule set forth is that it preserves the state's authority to make a determination on whether a point source discharge will comply with applicable water requirements, but there are added process requirements. And these are to ensure that the states have sort of justified the regulations or provisions that they are basing their determinations on. So it requires a little bit more in terms of explanation from the state, and the state can't sort of make a one-line determination of why it's within their scope. But the rule also outlines the federal agency's authority, and that includes setting a reasonable period of time by which states must act. And it's an important role in reviewing kind of the procedure for the 401 process. And so it provides a role for federal agencies to evaluate, whether the state is identifying the applicable water quality provisions we just talked about. So the federal agencies given a little bit more authority here in making determinations under the statute. And also, the federal agency determines whether waiver occurs. And this is really important for project proponents who need clarity, and it wasn't always clear sort of to which agency they go and who has the proper authority to make that determination. So that's where we are now. And before turning it over to Sara, I wanted to preview a few important issues on the horizon. And so the first is just implementation. EPA issued its rule in July of this year, but individual agencies, say FERC and the Army Corps of Engineers, they have regulatory terms that they must define. They have existing regulations and policies that may need to be changed. And so just for example, FERC issued a notice of proposed rulemaking in October that would define the reasonable period of time, and they the NOPR defines it as the statutory maximum of 1 year. But what we're going to see is as agencies implement the rule, and perhaps more importantly, as they're faced with interpreting the new rule and issuing permits, we're going to start to see the true impact of the rule and how that takes shape. And so those federal agency determinations and policy changes will eventually become subject to court challenges and litigation. And we're not at that point yet, but what we have seen is our direct challenges to EPA's rule that were filed, shortly after the rule was issued in July. And so several of the cases pending are identified on this slide. I'm not going to walk through each case, but they contain sort of some common claims, and they're claims that are familiar in rulemaking challenges. And so, for example, they assert violations of the Administrative Procedure Act for a number of reasons, including that the rule lacks a rational basis for the rule, and they also assert that the rule goes beyond the boundaries of the Clean Water Act, which is sort of outside of the EPA and more specific under the Clean Water Act. Some of the complaints include assertions that the agency has inappropriately disregarded prior agency policy. And so we might expect this given the history of the 401 regulations and sort of the lack of revision to the regulations. So we're going to see these challenges play out in 2021, but similar to what Daniel was talking about earlier, we can also expect to see some more immediate action being that's taken by the incoming Biden administration. And so the sequence of reform that was implemented by the Trump administration, again, is familiar in terms of executive order, guidance, rulemaking, and so we may see some similar tactics being used to undo some of the Trump administration's reform actions. But again, as demonstrated by sort of the timeline of the Trump administration's actions, these are really heavy regulatory initiatives. They require significant support and effort to carry out. And so the realization of kind of the reform actions taken by a Biden administration with respect to Section 401 may carry well into the first term. And now I'd like to turn it over to Sara, who will be providing an update on the NPDES delegation in Texas.
Thank you, Kevin. Good morning, and thank you again for joining us. I'm going to be providing updates on two topics, NPDES delegation in Texas and the County of Maui case, County of Maui versus Hawaii Wildlife Fund. They have potential to be very important to some of you and will hopefully be interesting to those who are not directly affected. I'll start with the developments related to House Bill 2771, passed by the Texas legislature in 2019. That bill provided that upon the EPA's delegation of the NPDES program to the Texas Commission on Environmental Quality for discharges of wastewaters to surface water from certain oil and gas activities, jurisdiction over the wastewater discharges would be transferred from the Texas Railroad Commission to the TCEQ. The legislation specified that it applied to produced water, hydrostatic test water, and gas plant effluent. In regulations implementing House Bill 2771, the TCEQ broadly defined produced water to make the intent is for jurisdiction over all wastewater from oil and gas activities in Texas that will be discharged to surface water will be transferred upon delegation. An application that consisted of a program package was filed by the governor with EPA Region 6 on October 12, 2020. EPA Region 6 sent a letter to the governor on November 12th stating that EPA had determined that the application filed on October 12th was complete and started the 90-day clock for the EPA to make a decision to approve or disapprove the package that was submitted. The steps that are set out in federal and EPA's regulations at 40 CFR 123 that must be completed following receipt of a complete application are the publication of notice of EPA's receipt of the complete package in the Federal Register and in newspapers in the state that open a 45-day comment period. At least 30 days after publication of the notice, EPA must hold a public hearing on the program submission. EPA is required to prepare a responsiveness summary that identifies public participation activities, summarizes the comments and EPA's responses to those comments. And if EPA approves the program, it will notify the state and publish notice in the Federal Register of its decision. So, notice was published on November 27th, last Friday, after a bit of drama about trying to get the notice published as quickly as possible. A virtual hearing will be held likely in early January, and that date was not included in the Federal Register notice. The comment period closes on January 11th, 2021, which is the 90th day after October 12th. Therefore, an extension will need to be approved by the state to allow EPA time to respond to the comments received, because obviously the 45-day comment period ends on January 11th, which is the 90th day. So that's EPA, I think, is working with the state to come up with an extension date. And then on that date, EPA will act to approve or disapprove the program. It seems likely that the extension will be about a week. But if you are interested in this topic, and you can look for information as we obtain it in terms of what the virtual hearing date will be and the updated date for EPA action. Send me an email if you are interested, and I will get back to you when I know the dates, and or we'll get something on our website. So the second update relates to the County of Maui versus Hawaii Wildlife Fund. You will recall that the decision in the County of Maui case established a functional equivalent test and set out factors to be considered in determining whether a discharge of pollutants that travels through groundwater to surface water must be permitted under Section 402 of the Clean Water Act. The U.S. Supreme Court left it to the courts to provide guidance through decisions on individual fact situations and to EPA to provide administrative guidance on the meaning of the functional equivalent test. So what has happened since then? Because that decision came out in April of this year, EPA said in the summer that it was working on a formal guidance document, but none has appeared, and it's my understanding that it is unlikely that will be forthcoming before the end of the year. EPA has stated that the decision took it by surprise, and it appears that EPA has not had time to work on and to obtain necessary approvals to issue a formal guidance. So administrative guidance will be left to the next administration. And the courts have not yet provided judicial guidance. Several of the cases pending in the courts or that were anticipated to be appealed have settled instead. The Maui County case itself was remanded to district court and is going through discovery. Oral argument occurred earlier this month in Prairie Rivers Network versus Dynegy Midwest Generation in the 7th Circuit. In the lower court, Prairie Rivers Network argued that Dynegy was discharging pollutants from coal ash ponds to the groundwater that is hydrologically connected to surface waters. The lower court dismissed PRN's case against Dynegy. PRN appealed following the Maui decision. PRN is seeking a reversal and remand to the district court so that the court can review the facts against the functional equivalent test. Dynegy lawyers asked the 7th Circuit to address the merits itself rather than remanding. It didn't appear from the questions that the 3-judge panel was keen on that approach, but we'll see when there is a decision. So that's one to watch. And obviously, we will continue to watch further developments. As an example state with regard to implications of the Maui County decision, I spoke with the TCEQ, and in the absence of federal guidance to the contrary, they are business as usual. As you have probably heard many times from us, the state of Texas includes both surface and groundwater within the definition of water in the state, and the state water quality statute requires permits for discharge into or adjacent to all waters in the state, including groundwater. So TCEQ already includes requirements and permits requiring liners of certain quality for surface impoundments, maintenance of those liners, and repairs if there is evidence of a leak to groundwater. They plan to continue to address any implications of the County of Maui case by continuing the requirement to fix leaking impoundments, rather than attempting to regulate seepage to surface water via groundwater, which they believe would be much more complicated. And as you know, as we know, EPA asserted its position in the Maui case that many states regulate ground discharges to groundwater already, and that was the most appropriate approach to take. So we'll see what happens with regard to administrative guidance from the next administration. So thank you very much for your time. I will now pass the virtual talking stick to my partner, Ann Navaro, back in DC, who will discuss Section 404 nationwide permits.
Thanks very much, Sarah. So I'm going to move on to topic 4 in our cornucopia of Clean Water Act topics. First, a little bit of context, as I'm sure most people on the phone are familiar with. The Corps of Engineers has permitting authority under Section 404 of the Clean Water Act. And under that section, the Corps may issue permits for the discharge of dredged or fill material into the waters of the United States, whatever those waters may be, as Daniel Pope explained. And that permitting authority includes the authority, the express authority in the Clean Water Act to allow dredged or fill material, the discharge of that material into for categories of activity. So the Corps can issue general permits, and nationwide permits are a type of general permit issued by the Chief of Engineers that are designed to allow permittees to go forward with their activity, in some instances without even further notifying the Corps, or with hopefully little delay or paperwork. The nationwide permit program is really a critical program, both for stakeholders and for the Corps of Engineers. The Congressional Research Service has estimated that of the thousands of permit-related actions that the Corps takes every year under Section 404 of the Clean Water Act, 97% of those actions are under general permits, including nationwide permits. So the viability of that program and its ease of use is critical both to the agency that is often resource constrained and to the permitted and regulated public. There are currently 52 nationwide permits that authorize a whole range of actions, ranging from placement of aids to navigation to activities related to utility line construction. And just to note that while most of the nationwide permits authorize discharges under the Clean Water Act, some of those nationwide permits also authorize activities under Section 10 of the Rivers and Harbors Act. So the nationwide permits are good for 5 years pursuant to the statute, but the Corps has proposed revising its set of nationwide permits and reissuing all of them a year early. And that is in furtherance of the Trump administration's efforts to streamline infrastructure permitting. So the Corps of Engineers a couple of years ago identified ways that it could further streamline permitting under the nationwide permit program and proposed modifying and then reissuing the permits. And it's taken until now in order to fulfill that intention. In fact, the public comment period on those proposed nationwides just closed recently on November 16th, so a couple of weeks ago. And I imagine many of you may have been involved through your trade associations in providing comments on the Corps' nationwides. The Corps of Engineers intends to issue the new nationwide permits before January 20th of 2021. So that is the intention, and we will see if that can be achieved. The Corps' nationwide permit program it tends to be non-controversial in many respects, but has proven to be very controversial in a few important respects. So I think in order to respond to recent litigation challenging Nationwide 12, the Corps has proposed dividing Nationwide 12 into 3 different permits. One would exclusively be for oil and gas pipelines, and the other 2 would apply to telecommunications, electrical lines, and pipelines transporting other things like water. So it's my understanding that proposed division was in response to litigation challenging Nationwide 12, but that proposal has been quite controversial in the regulated community. And a lot of commenters have expressed a lot of concerns about the Corps' proposal to divide Nationwide 12. So I think it's still up in the air as to what the final nationwide permits will look like with respect to that proposed division. The Corps also proposed requiring a pre-construction notification under Nationwide 12 for any oil and gas pipelines in excess of 250 miles. So in other words, regardless of any of the other circumstances of the project, the Corps would want to be able to review the use of Nationwide 12 for any oil and gas pipelines exceeding 250 miles. There's also a lot of adverse comment, as you all can expect, on that proposal, because it makes using the nationwide permits more time-consuming and complicated. And it also doesn't seem to have a very direct link to the nature of the Corps' jurisdiction, which is waters of the United States. Of course, in any given 250-mile stretch, there may be a huge range of different impacts on waters of the United States, depending on whether the project is in the arid Southwest, in New Mexico, for example, or in Louisiana. So it'll be interesting to see how the Corps' final nationwides come down in that respect. The Corps also proposed some other changes, some positive changes to Nationwide 3, which applies to maintenance, and I know is frequently used in the regulated community. It can now be used for certain changes to any serviceable structure or fill, whereas previously it could only be used with structures or fills that had been permitted in the past by the Corps of Engineers. The Corps is also proposing to add a new mitigation requirement across the board for any losses of stream beds in excess of 1/10 of an acre. So that would add some additional complication and burden to the program. The expiration date of the nationwide permits is something worth keeping an eye on. It's not clear how the Corps is going to do that, but it may be that the current set of nationwide permits may expire essentially a year early to avoid having two sets of overlapping nationwide permits in effect. So it will be important for companies that have current nationwide permit verifications or are currently using nationwide permits to pay close attention to that expiration date when they issue the final proposal. So just some final musings on the Corps' nationwide permit program. As I'm sure many of you all have seen, there has been very active and high-profile litigation, as I mentioned, over Nationwide 12 that resulted in a temporary suspension of the availability of Nationwide 12 for any projects across the country, which resulted in a flurry of additional litigation proceedings, as well as a lot of concern across the regulated community. And the Supreme Court has temporarily restricted that order so that it is no longer preventing the use of Nationwide Permit 12 for most projects at present. But that litigation has not concluded. It is pending in the Ninth Circuit. And so everyone will want to keep an eye on how that plays out and whether it impacts the availability of Nationwide 12. Many of the arguments that have arisen in the Nationwide 12 case could be relevant to challenges to other nationwide permits. So we may want to keep an eye out for new fronts in litigation over the nationwide permit program. What's the next nationwide permit that different stakeholders may object to under the Clean Water Act and under various other environmental laws. In the past, there have been challenges to Nationwide 21, which dealt with coal mining. There have also been challenges to other nationwides dealing with shoreline protection. So I expect that we will see litigation in the nationwide permit context continue, not only in challenges to the nationwide permits themselves, but in challenges to individual verifications in order to try to stop or delay project construction. So one question that some folks who are regulated under the Clean Water Act are asking more intently these days is whether projects can be designed to avoid Corps of Engineers jurisdiction in instances where there is concern that project-specific litigation or litigation aimed at a nationwide permit generally could have implications for a company's particular project. And I certainly think that's a wise thing to consider as we see how litigation plays out in the coming months. Another question to consider may be whether an individual permit application is warranted. Even though individual permits are, again, more time-consuming and resource-intensive, they may also avoid some of the current litigation issues that we see around the nationwide permit program. And certainly, as with every other topic that we're discussing these days, what 2021 will bring for the nationwide permit program is a bit unknown. Typically, when there's a new administration, the Corps of Engineers and its regulatory authorities are not necessarily the first place a new administration looks to have influence. As you all may know, the Corps of Engineers itself does not have any political appointees, and it sometimes takes a while for the Assistant Secretary of the Army for Civil Works, who is the political appointee that oversees the Corps and other Army entities, to determine, what its policy agenda may be going forward. So something also to keep an eye on. So thank you very much for joining us this morning. We really enjoyed putting this together for you. And please feel free to follow up with us if you have any questions.